In this lesson, we're going to go over the governmental intent requirement in equal protection challenges. Of course, this is a gateway issue in our equal protection analysis. So when a plaintiff alleges injury under the Equal Protection Clause on grounds that the government has passed a discriminatory law based on a suspect or quasi-suspect classification, the court will not apply a heightened level of scrutiny unless the plaintiff first establishes that the government had the intent to discriminate against the protected class. Of course, this comes from Washington v. Davis, a landmark Supreme Court decision from 1976. So as a big picture refresher, if we think back to our last lesson here on equal protection, we know generally our equal protection analysis hinges on the level of scrutiny that we're applying. If we're looking at a constitutional law fact pattern and we see a discriminatory law and we're trying to determine whether that discriminatory law is in violation of the Equal Protection Clause of the 14th Amendment, we know it really comes down to, well, what level of scrutiny are we going to apply to this law? And we know the level of scrutiny we apply really depends on the classification the plaintiff is alleging the government is discriminating against. Is it a suspect classification, a quasi-suspect classification, or some other classification? Kind of a classic example I like to use is age requirement laws. Take any law that requires a minimum age to engage in activity. Think about drinking alcohol. You know, if the government passes a law that requires a person to be at least 21 years of age to consume alcohol, why is that law not in violation of the Equal Protection Clause of the 14th Amendment? Well, it's clearly a discriminatory law, right? If we look at that law, you know, people who are 20 years old are not allowed to drink alcohol. People who are 21 years old are allowed to drink alcohol. So it is discriminatory. It's treating people differently based on their membership in a certain classification. The problem is the classification is unprotected. Age is not a suspect class. It is not a quasi-suspect class, meaning it's an unprotected class under the Equal Protection Clause. Therefore, if the court is going to try to determine whether a minimum drinking age law is constitutional under the Equal Protection Clause of the 14th Amendment, the court is going to apply rational basis. And we know, for the most part, the government is going to prevail. And it's going to be under rational basis whether the law is rationally related to a legitimate government purpose. We can easily see how a minimum drinking age law is rationally related to a legitimate government purpose. Therefore, the law is going to be upheld as constitutional under the Equal Protection Clause of the 14th Amendment. Okay, so we see that law, though, really hinges on, that analysis really hinges on the class that's being discriminated against. Okay, age is an unprotected class. It does not receive a heightened level of scrutiny. Therefore, the law is generally upheld. Of course, if we change the classification there that's being discriminated against by the government from age to, say, sex, say the government passes a law that says men are no longer allowed to drink alcohol, women are allowed to drink alcohol. Well, now we have discrimination not based on age, we have discrimination based on sex. Sex is a quasi-suspect classification. Now the court is going to apply a heightened level of scrutiny because we have a discriminatory law based on a quasi-suspect classification. Therefore, the court is going to apply intermediate scrutiny to determine whether that law is constitutional under the Equal Protection Clause. This is a heightened level of scrutiny. This is going to be more difficult for the government to prevail in this situation, right? When we're applying heightened levels of scrutiny, like intermediate and strict scrutiny, it's more difficult for the government to prevail than when we're applying rational basis. And actually, that fact pattern is based on a real case. That's Craig v. Boren, right? The government actually did try to do this. They tried to say men in certain situations are not going to be allowed to drink alcohol, where women in the same situations are going to be allowed to drink certain types of alcohol. That's Craig v. Boren. We know there the court applied a heightened level of scrutiny, intermediate scrutiny, because it was discrimination based on sex, and the law gets struck down in violation of the Equal Protection Clause. So big picture, right? All of this is to say the analysis depends on the level of scrutiny we're applying. Fundamentally, whether the law is upheld or not under the Equal Protection Clause is going to come down to the level of scrutiny we're applying. And we know the level of scrutiny we're applying depends on the class that's being discriminated against by the government. Is it a protected class, meaning a suspect or quasi-suspect class, or is it some other class? Because if it's suspect or quasi-suspect, meaning it's a protected class, then we know we're applying generally a heightened level of scrutiny. It's going to be more difficult for the government to prevail. If it's some other classification, then we're applying our default standard of review, which is rational basis. In most cases, if we're applying rational basis, we know the government will prevail. Okay, so with all of this in mind, and by the way, that's a refresher of our last lesson. If you want more details on just the big picture equal protection analysis, you have to go back and watch our overview lesson on equal protection. But just as a quick refresher before we jump into this gateway issue. But with all of this in mind, let's think about the governmental intent to discriminate as a gateway issue in equal protection claims. Basically, what this rule is saying is before we can apply a heightened level of scrutiny in our equal protection analysis, we have to make sure that the plaintiff first establishes that the government had the intent to discriminate against the protected class. Okay, so we get this governmental intent requirement as a gateway issue. Now, it's important to recognize sometimes this is going to be very straightforward. In the example we just used, which comes from Craig v. Boren, right, which is a very basic sex discrimination equal protection case. If we look at that law, right, women are allowed to drink alcohol. In certain situations, men are not allowed to drink alcohol in certain situations. Just to simplify this, let's make this a hypothetical, right, based on Craig v. Boren. And let's say the government passes a law that says women are allowed to drink alcohol, men are not allowed to drink alcohol. Okay, if we're looking at that and we're trying to decide, does the government have the intent to discriminate against a protected class? Based on that law, we can easily say yes, right? That law is facially discriminatory on the basis of sex, which is a protected class, right? It's a quasi-suspect class subject that's entitled to a heightened level of scrutiny, intermediate scrutiny. Okay, and if we look at the face of that law, the law is literally saying men are not allowed to drink alcohol, women are allowed to drink alcohol. The intent of the government is very obvious. The government has the intent to discriminate on the basis of sex. They're not trying to hide this in any way. It's on the face of the language of the law. It's express facial discrimination based on sex. Okay, so the plaintiff would have zero difficulty establishing that the government had the intent to discriminate in that case. Okay, so none of this would be a big issue if we have a facially discriminatory law against a protected class. Then we don't really have to worry about the plaintiff establishing governmental intent. That's going to be very easy if the intent of the government is basically included in the language of the law itself. And a lot of times that's the way it goes. Other times it's not so easy to determine what the government's actual intent is based on the language of the discriminatory law or the alleged discriminatory law. And really, this concept, it's best to think about in terms of discriminatory intent versus disproportionate impact. That's where we really see this difference illustrated. Discriminatory intent versus disproportionate impact. So we say here, absent rare cases, and we're going to talk about the rare cases at the end of this lesson, absent rare cases a law will not be held unconstitutional under the Equal Protection Clause solely because the law results in a disproportionate impact toward a protected class of people. Okay? So we have to understand the difference between discriminatory intent and disproportionate impact. Okay? So we can go to the case that this comes from, which is Washington v. Davis. Okay, in Washington v. Davis, what we basically have is the Washington, D.C. Police Department instituting a hiring policy. So the police department institutes a hiring policy. And under this policy, they're going to require all applicants seeking employment as a police officer to take this qualifying test. It's a written exam that basically was testing verbal and communication skills. The idea is police officers need to be able to communicate. So as a part of the application process, we're going to have this test that measures an applicant's ability to communicate with others. Okay, so this test gets administered, and what ends up happening is we have a plaintiff who comes along who shows that, well, this test actually, when we look at the statistics, like the results of the test, it turns out that black applicants fail the test at a disproportionately higher rate than white applicants. And what ends up happening is because we have more black applicants failing this test than white applicants, more black applicants are excluded from the hiring process, and basically less applicants that are black can become police officers under this procedure where we have this test being administered where black applicants are failing at a higher rate than white applicants. Okay, and the court looks at this and basically says, in that case, right, this is a disproportionate impact. This is not necessarily, if we look at the face of this law, it's not necessarily discriminatory intent. The court says a law will not be held unconstitutional under the Equal Protection Clause solely because the law results in a disproportionate impact toward a protected class of people. Generally, the plaintiff must offer additional evidence to establish the government's intent to discriminate. So what the court is basically saying in Washington v. Davis, if we look at the Equal Protection Clause and we look at the purpose, the meaning behind the Equal Protection Clause, really the Equal Protection Clause is preventing purposeful discrimination, invidious discrimination. Kind of this idea, it's really prohibiting bad faith discrimination by the government. It's not guaranteeing that every person is going to be treated equally in all circumstances. You know, the court is basically saying, look, sometimes laws are going to have disproportionate impacts on different classes of people. You know, we can have facially neutral laws that affect one group more than they affect another group. But that doesn't mean the government's being purposefully discriminatory against that group. And that's really what the Equal Protection Clause is preventing. You know, when you think about Brown v. Board of Education and these seminal cases in the equal protection analysis where we actually have the government engaging in, purposeful segregation based on race. The court is saying that's what the Equal Protection Clause is really prohibiting. We can't extend the meaning of the Equal Protection Clause to prevent disproportionate impact toward, certain groups based on a facially neutral law. So we get this idea of the intent requirement. In order for the court to apply a heightened level of scrutiny, the plaintiff has to establish that the government had the intent to discriminate. And what the court says is a disproportionate impact toward a protected class of people by itself is not sufficient in most cases to establish governmental intent to discriminate against a protected class. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP, for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.